And then,
Good morning, everyone. Welcome to another forms class. Today, we're going to be talking about manufactured homes in parks. Woohoo! On leased land. There's a big difference with those. A lot of things to go over and to remember when you're dealing with these. I've literally had, I don't know why, just a string of questions on these lately in the past few weeks. There's been a lot of issues and brokers run into problems. I'll even tell you guys a horror story about a listing broker at a different company who sold theirs twice, and we were one of the buyers. So, a lot to discuss. Let me go ahead and share my screen. This thing. All right. Hide all this stupid stuff. All right. So let me start out here. All right, manufactured home, purchase and sale agreement. So something to keep in mind with this is that there are going to be a lot of the boilerplate same language that's in Form 21 and 28 that we've already gone over Form 21 in depth in two parts. This one we're going to go through in just one part because we're really going to just touch on the main pieces and components of what's so different in dealing with manufactured homes in parks. So use, a manufactured home or mobile home can either be real property, an example, real estate, or personal property. In order for a manufactured home to be real property, it must be affixed to land and the certificate of ownership or title must be eliminated. So an example, the title of a manufactured home as personal property, just like a car, right, must be eliminated in accordance with Washington law. Manufactured homes that are personal property are generally located within a mobile home park. In those parks, the residents own the title to the manufactured home as personal property, and they lease the land under the home from the park owner. So RCW 1885 allows brokers to represent buyers and sellers in the sale of manufactured homes as personal property in conjunction with the sale or lease of the land upon which the manufactured home is or will be located. See Legal Bulletin 195 for additional information. There's a lot of other stuff that you can get from this. Just bring it right up. That's kind of crazy. So here you go. So this is, I don't want to print it, but you can get the PDF. Basically gives you the quick breakdown of exactly what needs to be done. But we're going to dive in deep anyway. But if you ever need that, there is more information. Let's get back to our form. Okay, Form 23 should only be used for transactions where title to the home has not been eliminated. An example, the home is personal property and the home is being sold in conjunction with the lease. So if it is just a manufactured home on its own land and that you own the land, you are not using the 23. We actually had a deal just last month where our listing was a manufactured home. They owned the property, it was in Auburn, and the buyer broker submitted their offer on a 23. So we're like, no, you got to redo this whole thing. You know, that's only for leased land. This, you own the land. Title's been eliminated also on this property. So fill in completely. So be sure it is completely filled in. The only blank that is not required to be filled in is the MLS number. The agreement may be legally unenforceable if any other blanks are not filled in. If a blank is not applicable to this sale, mark it NA or line out the sentence or clause. So something to keep in mind, they always say this. This is kind of a standard just disclosure in the forms manuals to all of the forms, really. If you don't fill in even the blanks that are default, it basically makes it look sloppy. You got real estate attorneys that are reviewing your deals, they're looking at everything, and once they see that, oh, this blank is left, then they start, you know, picking apart your deal like, okay, you didn't really give very good reasonable skill and care. That's the first thing that they'll identify when they're like trying to do a lawsuit. So make sure, even if the buyer's going to go with the default, fill in the blanks, all of the blanks, if it is applicable. If it's something that's not even going to apply, you're not checking a box, then don't fill it in. All right, Jason, you want to read C?
Sure. Limited license to practice law. Under the Heritage House and other cases, the courts will hold you to a standard of care of an attorney in filling in this form. You are only licensed to fill in blanks of attorney written forms such as this one, or insert attorney drafted or approved special clauses.
As you guys know, we do have approved office clauses in transaction desk that you can access at any time, which makes your life easier. Everything that you pretty much should need should be in there. If you're drafting and writing your own language, just like it says, you're pretty much acting as an attorney. So, D, property information verification period. This is something that is very commonly misunderstood. Constantly people, I see even brokers sometimes in our own office actually waiving this section or saying it's already satisfied when they have an inspection. That just doesn't make any sense. It's actually could be detrimental to sellers. So even listing brokers don't quite understand this. It's basically the easiest way to kind of remember this section is that in the event that the buyer doesn't have time to do their due diligence and to investigate the property to the full extent, then pretty much their only option later in the future is to what? Lawsuit, to sue the seller. They didn't get a chance to verify the stuff, right? It's a boilerplate item that's in all of our purchase and sale agreements. And it's the information verification period. Now that you can choose how long a time you want. So realistically, whenever you satisfy and waive it, you removed all the rights for the buyer to verify everything, including marketing. We've actually gotten brokers, or excuse me, we've gotten buyers out of deals on contracts that they had no inspection contingencies on and that they waived the Form 17, but yet they had this still intact. And we had one broker, you know, basically, or the listing broker that told our buyer, like, well, you can't, you know, you can't walk. If you do, we're keeping your earnest money. You don't have a right. And we found that they left on their flyer, it said that the property had AC. Property has AC, and it didn't. And we called that listing broker and we said, well, we are terminating based on the information verification period. So when you get to the forms 90s, so we sent the 90, that's verification, 90Z. So you sent a 90Z in a form 50, and we stated that, well, we're terminating based on the fact that you stated the home has AC. And the listing broker said, it doesn't have AC. I never said that. It's not in the listing. I don't know what you're talking about. We said, okay, well, here's a copy of the flyer. And we got the buyer out. And here they had just changed their mind. You know, it wasn't even like, you know, they didn't have an inspection and they waived Form 17. So it's one of these things that you literally
So for a days, a lot of times I'll just match it up with my
inspection.
Yeah, inspection. So if it's
Absolutely.
like, so if you have like 5 days on your inspection, you just put 5 days on here.
That's the best.
Okay.
That is literally the best thing to do. Or, you know, especially, you know, 5 and less, weekends and holidays don't count.
Yeah.
So you end up getting more.
Yeah, sometimes 5 could be like 10.
Exactly. Yeah, depending on the timing of year where you're at between holidays and weekends.
Yep, you do it on a Thursday and then there's a holiday on Monday, and the next thing you know, it's been like 10 days.
Mhm. So it is a critical piece to what we do, and you gotta explain it. Unfortunately, a lot of listing brokers don't quite understand it. If you're in multiple offer situations, you're waiving inspection, you're waiving Form 17. I mean, I get it. That's the market that, it pretty much will dictate if you to do this as well. You're gonna be probably satisfying waiving it too. So
Unfortunately, we're not in that market, right?
I know, right now, you're not in that market, so you really should not be marking this. You should be filling this in probably by like 5 days at least. Okay? All right, let's get back to the top.
But you know, an interesting little thing that I found out about homes in a park that's leased.
Yeah.
Is if the park is to close, the owner of the park has to give, people that have their manufactured homes on there a year
Year.
notice.
Yep.
And they have to give them a $15,000 moving, like payout to move from the park.
If they close on them
Yep,
in their lease.
in their lease,
Yeah.
which is, I was really, so you can't do the normal eviction process.
Mhm. Nope, it is quite different. All right, so I've explained that pretty well. You guys have to. Let's see, buyer doesn't review, buyer should verify. Okay, so it also states that buyer should verify the accuracy of information contained in the listing, flyers, advertising, other marketing, and the Form 17. If buyer discovers a material inaccuracy in the information provided by seller or the listing brokerage firm, buyer may elect to terminate the agreement within the negotiated period. If buyer does not terminate, then buyer will waive the right to terminate and the transaction will move forward. So it just automates to move forward. Let's see. All right. All right, obviously fill in the date, the buyer's name, seller's name. Insert the date the agreement is prepared. There's no blank to insert mutual date. I wonder if they will ever do that. It'd be kind of nice. Mutual acceptance occurs, so this is very important. When a party accepts an offer by signing it without making any changes and delivering the signed agreement to the other party. You can confirm the date of mutual acceptance with a fax mail confirmation sheet if the acceptance was faxed to the other party, or with the email received date if the acceptance was emailed to both the broker and the brokerage firm email addresses specified on page 1 of the purchase and sale agreement. A received stamp will also confirm the day that the acceptance was delivered. Alternatively, you may make a note of the day on which you received or delivered the final acceptance. It's still very, very rare we're seeing people fax stuff. It has, I mean, we had someone like towards the winter time that someone was up at their cabin and they had a fax machine and that they had no, they had no internet, but they still had that and they actually got things to work.
It's still in transit.
It still works, yeah. So once in a great while, you might be kind of in a pickle and you're gonna have to like do something like that, but it still works. MLS number, obviously fill that in. Offer expiration date, very important. Insert the date by which buyer's initial offer must be accepted. Note that an acceptance is not legally effective until it is delivered to buyer broker, or at the licensed office of the buyer broker. Acceptance must be delivered by 9 p.m. of the specified date or the offer expires. Acceptance shall not be effective until a signed copy is actually received by seller, by listing broker, or at the licensed office of listing broker. If no expiration date is specified for an offer or counteroffer, the offer or counteroffer shall expire 2 days. There's so many people that miss this. Just because they leave it blank for their expiration date does not mean it is gonna go forever until you accept it. It still expires in 2 days. And that's for anything basically that you're countering back and forth if you don't specify an expiration. So let's say Gerwinder has a listing and Jason's writing it up. And he puts today's date on it and he sends it over,
9 p.m. tonight.
right? So it expires at 9 p.m. tonight. If Gerwinder counters that offer,
Before 9 p.m.
no, doesn't matter, after 9 p.m.
Okay.
And he sends it back at 10 p.m. When does that counteroffer expire?
Well, technically he was late. Get it back to you, but if you wanted to.
He's countering anyway.
Yeah. 2 days, but you could say the gray area is, we decided not to move forward with this because you sent this after 9 p.m.
Yeah, but he's countering you.
Yeah,
No matter what, he's countering you. So he didn't accept what you wrote.
yeah,
So his seller's like, no, we won't take that, but we'll do this. And he just countered the price. One spot. But Gerwinder did not change the expiration date on the top of the contract. He just crossed off the line of the price, wrote his new price, his one seller initialed, and sent it back to you at 10 p.m. So if today's the day, when does that counteroffer expire?
well, the next, it'd be going into the next day, so the next day would be day 0. And then you'd have 2 days after that, right?
It's confusing,
Yeah.
huh? So I'm asking, Zoom people, anybody know?
So what day, was it Thursday? He did it on, we did this on Thursday, so Friday would be day 0 now, so Monday'd be 1, and then Tuesday'd be day 2.
You would think that, but it's
Yeah.
actually Friday. Because it doesn't matter that's after 9, because he has sent it that same day.
Okay.
The expiration date is the deadline of 9 p.m.
Hmm.
Brokers get confused all the time and think, oh,
It's the next.
I had someone like call this just like last week that, or actually I was last weekend. And they said, we got this counter offer back, but they sent it at 9:01 p.m. Does that mean is tomorrow's mutual?
Yeah.
What do you think?
It is still it's still the date.
It's still the date you signed it, yeah.
Hmm.
So it's the same date, commencing day is when you start counting.
Yeah, got it.
So it could be very confusing. All right, so. Do not forget, once an offer or counteroffer is made, deliver it to the other party as soon as possible. Delay could result in the other party claiming that it is your fault that he or she did not have time to consider or sign the offer before it was withdrawn or even expired. Withdrawals of offers or counteroffers. General term O counteroffer states that buyer has until 9 p.m. of the counteroffer expiration date to accept the counteroffer unless withdrawn. An offer or counteroffer can be withdrawn before acceptance is delivered to the other party. Withdrawal of counteroffer or offer must be communicated in writing. If a party decides to withdraw an offer or counteroffer, use MLS counteroffer withdrawal form number 36A. I just helped someone do this week. Their buyer was gonna give non-refundable $25,000 earnest money. You know, they're competing, a lot of offers on this one. And it was a really good deal. And then the buyer was like, wait a minute, no, I don't want to do 25. I said I could do up to 25, but let's only do, 15. And they said, I already, like, you signed it and it went, I sent it, and she's like, oh no, well, I don't, and so she called me like, Eric, what can I do? How do I do this? Can I just replace the front page, replace the part of the contract? Or I'm like, no. If you don't withdraw that other party can sign off on it and now you're in agreement. So it's a race against time.
Yeah.
So you got to get the 36A. You have to include that complete offer that you sent with the 36A. And the most important thing is you must, have your buyer sign it. And you must send it to both the listing broker and the authorized firm email address. You really have to be in a habit to send every document you're sending to the firm as well.
Your proof.
It's your proof. If we have to, if it comes down to it to where you like, oh, the buyer's email system got crashed and they cannot pull the record and they cannot see the email and you don't have proof, you know, you just don't want to be in that situation where it's gonna, you know, go to legal battles.
Well, a lot of other, on the other side will use like a Gmail or a
Yeah,
Yahoo or whatever.
oh yeah, Comcast or,
And so this is kind of similar to like if you do like a backup offer. So like a lot of times I'll have the backup offer and I'll have the withdrawal like prepared at the exact same time. So if we do go out and
Yeah.
find something else and then we can just send that withdrawal, I have to get signatures or whatever, just have it done.
yeah, you can do that, you know, you can have that ready at any time. But the thing about counter offers, I mean, once it's signed, then that you can't
Yeah.
withdraw it. You would have to then give the notice of, you know, terminating that they found something else. Because even in backups, you can walk. At least before the time they issue notice that you're in first position, at any time before that. So you're okay. But this is just extremely important though, to making sure you do that. I've told this story a million times, but I'll continue to tell it. And the long story short is the fact that one of our listing brokers in Bellevue, she had a really expensive house that they were like, oh, thought they were gonna get multiple offers. They ended up getting one. And it was like, you know, it was good, but it wasn't like astronomically good. Well, all of a sudden, after they countered like one little change to this deal, they counter the offer like early in the day, sent it over to the listing broker, or excuse me, sent it to the buyer broker, and they waited and waited. All of a sudden, a few hours later, another crazy offer came. You're talking like almost 300 grand over, huge non-refundable earnest money, a rent back with, you know, for $1. And it, you know, and it was closing in 2 weeks, all cash. And they were like, the seller like, we want to take this. How do we, you know, what do we do? And they said, well, we gotta you know, withdraw our counter offer because they had not received it yet. And here it's getting to the evening time because they're going back and forth and, you know, they got the proof of funds and they're just like, oh, this looks really good. Like, let's sign off on this. I can't send it to the other broker yet. Let's hold on to it. And then the sellers felt bad. They're like, oh my goodness, this is, you know, terrible. Like we're pulling the rug out on the first buyer, you know, feeling kind of bad. They were so nice. You know, they're kind of feeling a little guilty. But then they're just like, you know what? It's a transaction. It's, you know, they understand it. And here by this time, it's already like early evening time. So they said, yep, let's do it. So they sent the withdrawal of offer with withdrawal counter offer 36A with that counter offer that they had sent to the broker earlier in the day. And then they signed off and they sent the other one and they're like, yep, okay, we've got this other offer. We've got it. So, you know, congratulations. All of a sudden at like 9:30 at night, 9:20 at night, the buyer broker calls our listing broker and was like, oh, wait, I got it. I'm sending it over right now. I've sent it. The buyer signed it. And she's like, what happened? Why did you take all day? You were in agreement to this one change. You had all day, you know, and the buyer broker says, oh, I'm so sorry. I got caught up. I started watching the Oscars and I lost track of time. And when they saw the actual email come over, the buyers had actually signed it around 4 p.m.
Oh my God.
So it just wasn't delivered.
Doesn't count.
Doesn't count. Here, that buyer broker would have made like 40-something thousand dollars just on that transaction. One transaction. So it's like, you gotta, do not delay. Time is of the essence. They mean that for a reason. Anytime that can happen.
Yeah.
We just did it. We withdrew that. They resubmitted the offer. They ended up getting it. You know, they were just like, all right. I mean, you might be in that situation where you're gonna have to do it. You just have to be prepared. I know some brokers will actually have their clients sign that 36A and just have it sitting and waiting.
Yep.
They just sign it separate, they hold it, they have it ready, they literally have the email. It's all ready to go. All they gotta do is hit send and it's going to the authorized firm and to that other broker at the exact same time. In the event that they just kind of feel like, hey, maybe we shouldn't do this.
Yeah, where the hair starts.
Yeah. Yeah.
It's our only offer. There's some funky stuff in here. Let's
Mhm.
get out of this.
So if you're in that situation, just be prepared. That's the most important thing. Always try to use the separate MLS counteroffer addendum, Form 36, and make sure it is dated and signed. It is common to make changes right on the purchase and sale agreement and have all the parties' initial and date in the margin. If you do make changes to the purchase and sale agreement form itself, have the parties' initial next to each change and be sure they put a date besides each initial. You know how many times I actually saw this already twice this week? I don't understand. I don't understand how brokers are still doing this. It's such basic contract law. I mean, it's common sense. How could an attorney, how could anybody review a deal and know where mutual acceptance happened when you have dates and initials initials and signatures
You're
with
trying to
no
pull-
dates?
Try to pull out the authentic signs.
Yeah, that's what you would have to do. You would have to pull authenticized certificates
Yeah,
and see when did the client sign things.
timestamp.
Yep.
And a lot of times what I'll do on like a counter, if I know, like if I'm trying to force somebody to take a deal prior to the weekend and they have an offer review or something on like
Mhm.
Tuesday or whatever. And then they come back with like a counter at like full price or up whatever.
Yeah.
I'll always do like have it expire like Saturday, like right around their open house. So it's like they can't use me as a,
Oh, yeah.
to like shop against me type thing.
There you go.
Cause you, on the 36, you could put a time. when it
Oh,
expires.
absolutely.
Saturday at 3 PM.
Yep.
Right when they're 3 to 6 o'clock, open house starts.
Yeah, I love that strategy. That's a good one, Jason. Actually, that's really good. I like that. That's smart. Yeah, if you're gonna try to win it early, I would totally do that, because then it puts the pressure on, like, should we do the open or should we just take this?
Yeah,
Yeah,
Especially today's market.
yeah.
yeah.
So take
Right
it.
now, you would take it.
Mhm.
All right, names of buyer and seller for signing authority and title vesting purposes. Insert the name of buyers and sellers. Describe the status in which buyer is purchasing the property. For instance, if seller consists of spouses, insert both of their names. If buyer is married, specify both parties if they will acquire the property together, but specify only the purchasing party if only one is acquiring the property as a separate property. For example, Robin A. and Quinn D. Lee, a married couple. They actually need to update this because our forms actually now, because of the sign, you need to have first name, middle initial, and last name per profile. Because for sign and for all the other, because it actually separates them. So that's kind of funny that they still show that, but they should probably update that, but I understand what they're trying to say. If there's only one person signing, explain the status in which they are purchasing or selling, for example, Robin A. Lee, a married person acting as a sole and separate property. Or Robin A. Lee, a single person. If it is a corporation or other entity, describe the type of entity, for example, ABC, LLC, a Washington limited liability company, or XYZ Inc., a Delaware corporation. Great Ventures LLP, a Washington limited liability partnership. Note, be careful about using and or assigns. It is common for buyers to be identified as, for example, John Q. Smith and or signs. From a buyer's perspective, that language generally allows buyer to assign the right to purchase the property to someone else. However, from a seller's perspective, it could be trouble for seller if buyer assigns to another buyer who cannot perform. If seller executes an agreement that identifies buyer and or assigns, seller will be deemed to have consented in writing to an assignment as set forth in the assignment paragraph of the agreement. So realistically, oh, I'm surprised it doesn't say this. Huh. That's funny. They usually follow this up with language that states that the attorneys always suggest that in the event you're representing a seller and the buyers and or assigns, You would change that language at the top at and or assigns, you would counter that, or use the Form 36 and counter and state that buyer is, and you would state ABC Construction LLC, you know, and or and slash or assigns approved by seller. You could state it just that simple. That's what it's actually, the language from attorneys always states in that section. So that's kind of weird that it doesn't say that. They usually always follow it up with that.
A golden nugget with this is a lot of times, people will want to buy this property and they don't have like a trust set up yet.
Oh, you're right.
And so,
Yeah.
and it makes sense
Mhm.
because it's gonna be 1, 2, 3 living trusts.
Yeah.
Of what's gonna be vested in, but it's not set up yet.
Mhm.
So it makes sense and it's fine. What you don't want somebody to do is tie it up and then flip the contract and make 10 grand on the contract. And you don't know who they're flipping it to. But there is legitimate reasons for this. Sometimes even an investor might be buying it in their personal name, but it's gonna be a yet to be determined LLC that's gonna be
Yes.
vested on the property. So it makes sense, but you just gotta make sure you're doing the communication to know what they're doing.
Yeah, 100%. We dealt with a deal last year with one of our listing brokers here. Buyer broker, I won't mention the company, even though I want to. Came to the property, said, yep, my buyer wants it. And it was multiple offers, and he's like, yeah, my buyer wants it. You know, we're writing it up. And he's like, okay. Because the broker came by himself. And he's like, okay. So wrote it up, and of course he wrote it as his name. And it said, you know, something LLC, and he had it as and or assigns. And so I told our broker, I'm like, well, this deal, I don't know. It was kind of weird. The communication was very strange. And I told our broker that we needed, you know, you should counter this for it because it was an estate sale and the state and the attorney was handling it. And we actually stated, just like I talked about, and or assigns approved by seller. So they were like, okay. And then the attorney from the estates actually said, this is the first time in many years I've actually seen somebody counter this deal, because they ended up getting it, and he saw the language and he said, that's really good. Yeah, he goes, that's very smart. Yeah, so that broker actually got a couple more deals from the attorney just from that. So things like that, you never know where it's going to make a difference in your business.
The devil's in the details.
Yeah, totally. So anyways, they had no inspection. All of a sudden the buyer broker showed up, and he's like, the neighbor who knows the seller and knows the broker said, hey, looks like someone's there showing the house, and it looks like, I don't know, they're like looking up on, you know, onto the roof. I don't know if they're doing an inspection. And he's like, what? So he calls broker. He's like, hey, what are you doing? He goes, oh, I'm just showing one of my potential buyers. He's like, what do you mean showing one of your buyers? And he goes, yeah, one of my potential buyers. He goes, no, are you transferring this contract to someone else? And he goes, yeah, probably, we're trying to. Like, okay. So then, long story short, come to find out this buyer broker was the buyer. We looked up his LLC and we found out it's his.
Yeah.
He didn't disclose he was the buyer. The attorney got very upset about this. We did not approve him trying to assign the contract. And he tried walking. He tried getting out of the deal, so we got their earnest money. We actually went after them.
If he was to do that legitimately, wouldn't you have to put the form there that says that the realtor is related to this transaction? Even.
You would have to disclose in the deal.
Yeah.
Yeah, the attorney sent a very stern message to the DB.
Yeah.
And they lost their $3,000. So they got $3,000, you know, for that. But anyway, it's just stuff like that. Like, you know, it's just.
Well, another thing to talk about vesting. So I've had this come up actually a couple times where it shows like on the Tyler report, like the name of their natural born name, you know, husband, wife, or
Oh, yeah.
whatever. However, it's in a living trust, but it's not showing
Yeah,
on the county records when you first pull the prelim, but when they're doing the transfer, a title finds that it's
Right.
a living trust, and so then they gotta bring their trust paperwork in. So now I'm always asking, how is this vested, or is it vested in your natural born name, or is it an LLC or a trust? One of the things to try to get around that, because at the 11th hour, the sellers go in to sign,
Yeah.
but they can't because they don't have their.
all the
trust
paperwork, yeah.
So just another little golden nugget that I've kind of picked up the last like year or two,
So on title, it didn't actually say the
No.
trust, yeah,
but it isn't a trust,
yeah,
but it's not showing. So when they try to do the transfer,
yeah.
they can't do it because it's not in their personal natural name anymore.
Is that just because they didn't get it recorded
Um,
and updated?
no, it was recorded, but it wasn't showing on title at the county for whatever reason. And then title and escrow finds out like right at closing. And this has actually happened a couple different times because sometimes how they record the like trust paperwork.
Sense. Yeah. That makes sense, Jason. All right, so time to get into the nitty gritty of the form. Got to look at number 5 here. So manufactured home, the manufacturer. So this is where you fill in the actual manufacturer of the home, the serial number, the year it was built, what is the space number? If there's the tax parcel, it should be for that whole entire plat. It's all of it. Huh?
Kind of like a condo.
Yeah, it's like a condo almost. Yep, the whole community usually is on one big parcel. Or sometimes they are individual. It is weird. I think in the condominiumized kind of ones, you might see that, but. And then, of course, address of the property. Go back. Wait a ways. Okay, space number, tax parcel, number or numbers. Street address, county, zip, lease or rental rate. So select either lease or month to month and insert the amount of the monthly rent. So that is very important. Talking to Josh this morning, told him what form we're going over today in forms class, and he's like, "Oh, nice." He goes, I like, what common issues do you always run into these? He goes, "You'd be shocked how many times buyers have no idea, they don't understand that there's a space rent too." He just said that literally people were like, "Oh, we love this. This is awesome." And then like we want to buy it, and then like, okay, you understand like you're leasing there. They're like, "What? What do you mean? Oh, you mean to pay for the community and you get, but how much is that?" And it's $1,100 a month.
Yeah.
What? Like, oh my goodness. So you'd be surprised about that. Other thing too about he said is very common is people not qualifying.
Yeah.
And some communities require you to have a purchase and sale contract before the buyer can even apply, and some don't. So you really got to communicate to the management, company and find out what are their requirements.
Well, and some, it's like hidden that they're over 55 and you don't know until after the fact. So, but what I tell people about the lot rent is it's kind of like your big HOA fees on like a condo.
Yep.
It's kind of like the similar thing.
Very
And a
similar.
lot of times it could pay for your
Water, sewer,
yeah, maybe
garbage.
even garbage.
Yep.
So it's kind of similar to, so then they understand HOAs, but sometimes they don't understand the buying it and then also having the rent.
Yeah, it is definitely a little bit different. There's some good ones out there, that have like literally all utility, everything. You got water, sewer, garbage, internet, yards taken care of. Common grounds are taken care of and stuff like that.
Especially the over 55 ones.
Yeah.
A lot more.
Those ones for sure, because they know people aren't probably in shape
Yeah.
or condition to be able to maintain property like that. So yeah, there's some good ones like that. All right, included items. This is no different than our normal, other ones here. You got to mark every single item that's included, right? All of the appliances. Existing, but the things that are different are these ones: existing, expansion, and or add-ons. Very different. That's not on any of the other purchase and sale agreements for included items. Things to look out for is, are these expansions or add-ons connected to the property? They are supposed to be floating. Anybody in Zoom world know what that means? Because you guys are quite quiet today. What does a floating expansion or add-on mean? Anybody?
It can't pierce the shell of the.
That's right. If they are mounting a deck, an awning, a covered porch, railing, steps, all that kind of stuff is supposed to be floating and not piercing the membrane of the actual home itself. So if that is the case, LNI will not like it. And a lot of these, if you're getting lending, a lot of these require LNI inspections, and we'll talk about that in a little bit. What's your question, Eric?
So if they're doing add-ons to the mobile home, it can't actually be connected to the actual mobile home, or what do you mean by like pierce through?
Exactly what you think it sounds like.
Okay, I just wanted to make sure.
You cannot screw in mounting a deck, which most of the time you want that. You want the deck to be,
Yeah, attached, right?
most properties, single family residential, that's what you would do. You would not want it floating.
Basically a separate structure.
Yeah, it's a
Got
separate.
it.
But yeah, when they connect them, it's not good. Everything else is pretty much the same. Yeah, generator, yeah, all the other things, but this is the only other one. So make sure that if you are doing one of these and then it does have a deck or it's got one of those covered, huge giant, what do they call it? Pergola? Yeah, any of those things, make sure you mark those because they're not attached and they are floating. So you would want to make sure that you're marking those. So that is definitely one of the things that are different. All right. I'm gonna jump around now.
A lot of the parks will do lease options too, where they have like if they own it.
There are ones that do that. It is strange,
Yeah.
but yeah, they could do lease options on some. Don't see those as often, but definitely there. All right, obviously note general term C provides a list of items that are included in every sale. The list includes things like wall-to-wall carpeting, window and door screens, window treatments, water heaters, garage door openers, plants and trees planted in the ground, and all associated operating remote controls and access permissions. There is also a catch-all provision to include any item that is a fixture. A fixture is any personal property that is attached to the land or building that is regarded as an irremovable part of the real property. If there is a fixture on the property that seller wants to exclude from the sale, that item should be listed in excluded item provision in Form 22D. If there is an item that buyer wants to include in the purchase, that item should be identified in specific term number 5. If there's any potential uncertainty about a specific item, the parties should specifically address whether that item is included or not. If any of the included items are leased or encumbered, general term C requires that seller acquire and clear title to such items at or before closing. Very important to remember, when you're having conversations with buyers, you're walking them through properties, and if they identify an item, they're like, ooh, I love that hot tub. I love that, whatever, planter, that thing, whatever it is, you need to take a good mental note and to remember that, because you're going to need to write that in and make sure it's included. If they mention it, do it. Just do it. Or let's flip it around. It's the opposite. And they're like, oh my gosh, that ugly split pea green soup colored fridge in the garage that stinks. Because you marked the front page and it says refrigerators, if you just mark that, a seller could leave both the refrigerators there. So if a client does not want something, write it in. Seller shall remove the green colored fridge in the garage within 5 days prior to closing. You better do it before your walkthrough. So when you go to the walkthrough, that it's gone. So-
And on the other side, like if you're representing the seller and they have a chandelier that they love.
Oh, yeah.
And they want to exclude that from the sale,
Yeah.
and they want, well, can we just put that in? I was like, I would suggest replacing that now. So
Oh,
that
yeah.
there isn't any like confusion of what it is, instead of having it, the chandelier doesn't convey.
Mhm.
And then it's like, well, what is it gonna be replaced with? Kind of like on the flip side too.
Oh, yeah. I did a sale for a house many years ago. Gosh, it was probably about 20 years ago now. 19, 20 years ago, somewhere there. They had a Dale Chihuly. They had, friends of Dale Chihuly, and they had the craziest chandelier I've ever seen. And when they told me how much it was worth, I said, "What? Are you including this in the sale?" And they said, "No." I'm like, "Get it removed. You get it removed before we list it.
Yes, good thing.
If we list it and anyone sees this, they're gonna be like, we gotta have it.
Even if
Like, it's gotta have it."
That's safe.
Yeah, I'm like, gotta do it because we're gonna have such a hard time. And the wife was like, "Oh, but it's such a nice feature and they're gonna love, and maybe we can see if they can get to make another one." I'm like, that's gonna be a mess.
Take it in.
And we're gonna run to headaches. I
Yep.
promise you, it's gonna be really bad.
Yeah.
So
Yes.
thankfully they removed it.
There's something else next to
Guess how much it was to have it removed?
$5,000. 10 grand?
How much was
Seriously?
it?
11 grand.
And how much?
$11,000 to get it removed.
And that was just to pull, what was the replacement one? Did it cost them?
They did not get a Chihuly
Oh,
for
I
it.
know, I wonder what the.
Oh, I think they spent like,
$1,000.
yeah, 900, 800, I think bucks or something like that. I mean, it was nice, but it was not even
Right,
close.
yeah, but,
So,
but definitely consider that when you're walking through there.
oh yeah, because they had to have it insured. I remember why. They had it to remove it, transfer it, and have it insured. They actually had to have it insured. So I was like, okay. I never did find out how much it was worth.
Probably 50, 60, 70 grand, probably maybe even more, 100 grand.
Might have been 100, it might have been 100 grand.
Huh.
It was pretty impressive. But anyways, just like Jason was talking about, like if your client's got some kind of item like that, make sure get it removed before you take photos,
Yeah.
before you list. Because otherwise it's going to cause issues.
Right.
So many times that I've had complaint calls in the past, like, oh, and a perfect example is a chandelier. There was a really nice chandelier. They said chandelier is being removed, not included in the sale. The brokers did a great job. They put it in the contract that it's being removed, but you know what they didn't do? They didn't state what was it gonna be replaced with.
Yeah.
And all they replaced it with was one of those ugly plain domes. Probably like $40.
Well, and then also if you have it in the listening remarks that doesn't convey, but you
Yeah.
get an offer that comes in that has the chandelier checked and you didn't
Ugh.
remove it and it's signed, now it's included in the contract and it needs to stay. Or
Yeah,
has to stay.
yeah, it's just because it's in the listing agreement that, oh, chandelier in the, dining room is not included in the sale. It will be removed, 2 days before closing. If you have that in the listing and you wrote it up and you guys got mutual acceptance on a deal and that not included item was not added in there, guess what? It's included in the sale. It doesn't matter what's in the listing. So you could be in a situation where you gotta go to your seller and go, oh, I forgot to have this in there.
Missed it.
You missed it. Yeah, now we have to include it. So those types of things are gonna cause issues. That's why I really wanna make sure we talk
I
about.
also
this
got a
one.
little bit about the financing on these two. When they're in parks, it's completely different financing. And so a lot of times when they go in there, the appraisal will have like end of life, like ranges in there.
Oh,
The lender might
that's
not
right.
bid on it because these don't have a lifespan of a stick-built house.
Mm-mm.
So if it's an older one,
Well, they don't even finance on before what? 78,
It's like
77,
76, 78, something like that.
something like that.
Yeah, so but if it's old and they go out there,
Yeah.
like maybe it might be 80s, might go out there and say, there's maybe 10 years left of life on
Yeah,
this.
we're not gonna.
And
loan
we're not
it.
gonna lend on it. Or they'll do like a 5-year loan, and so then the payment along with the
Ooh.
lot rent, they won't qualify for it. Just a thing to keep in mind if you're out looking at older manufactured homes on a park.
Yeah. All right, forms of earnest money. We've covered this stuff before. We're not gonna do that one. We're skipping that. Default, obviously forfeiture. Closing agent, some escrows won't touch them. The ones in the park, it's kind of weird. There's a few of them that kind of like, send it to here. Insert closing agent's company name. This is required. You can also insert the individual escrow officer's name. This is optional. Do not insert words like as agreed to or to be agreed to later. I actually remember seeing these words way back in the day, which is scary. Closing date, insert the closing date. The sale must be closed. Obviously, do not pick a Saturday, Sunday, or legal holiday because they will not close it on those days. Possession date. Do not forget this. If you're choosing anything other than possession on closing, you will have to use the 65A or B, no matter what. Even if you wrote something like 3 days after closing, if you even state those, the words like, oh, why do I have to use the lease agreement? Why do I have to do that? Rental agreement, sorry, not lease agreement. It's a rental agreement because it's different. Doesn't, Washington State tenant law acts don't apply because it's under the cap of the 90 days. So just be really careful about this one, like making sure that possession's always on closing, if at all possible. All attorneys will tell you that where the highest risk in transactions happen is when you've got possession other than closing. And that's whether, regardless, if it's a buyer moving in early with the 65A or the seller staying on the property for some days, the 65B. It's never good.
I got a question on closing day. So say
Yeah.
for instance, your closing date is on a Monday and it's a holiday, that rolls to Tuesday, correct?
Yeah.
Yeah.
It does, but don't be shocked if escrow wants 22Y. They want a modification of closing date
Yeah.
because they've gotta have an agreement that the dates. Some of them are fine, they're like, it's fine, we're gonna do it, because the contract says that it will go to the next day. But there's just some title and escrows like, nah, we're not gonna do that unless we get it in writing.
Yeah.
It all comes down to the same thing of like the words on or before, for a closing date. Like when that's written in, some escrows will do it. Some of them will not. They won't touch it. And most of the ones that say they won't touch it, it's because they've been sued before. Yep. This one's a little bit different. Services of closing agent for payment of utilities. Obviously, it's got 22K. Most of the time, these state that, the HOA is responsible for most of the items. So you'll see HOA on a lot of the 22K. It should be included. You want to make certain that the buyer, the seller doesn't have any back, owing bills for any of those items. So just it's a good idea.
It'd be like a Highline Water District in
Yeah.
parentheses, HOA.
Yeah.
Paid for.
That's a good idea. I actually prefer it to say who the company is. And then in a parentheses, yeah, HOA. That's how you should be filling that in. Listing brokers, if you're helping the seller, have 22K. We actually heard from, I got 2 brokers now that have told me this in recent deals with Redfin, that they are requiring that the 22K be completely filled in
Addresses and everything.
with the addresses,
Yep.
phone numbers and websites and every detail and information be filled in on a deal. So don't be shocked if you hear that. I'm starting to hear this come
Just have
out.
that on that.
You just had it too?
That's what they wanted us to do.
Redfin?
Yeah, and then we also had a propane tank
Oh,
and they wanted to know.
lease
who-
paperwork.
Yeah, and then who was the one that filled it in the parentheses,
Oh, yeah.
which was, I've never had that before.
Yeah.
Oh, and they also asked for us to have a picture of what's left in the tank
Oh,
as well.
they got sued or something.
So,
Yeah,
that was-
that,
so I was like, hey seller, can you go take a picture of your tank and show what the
Yeah.
amount is? Cause I guess there's a reader or something on there, which
yeah,
I've never had before. That just happened like last month.
yeah, that's weird. But it's, it makes sense. They're supposed to be completely filled in. All right, very important section here. So buyer review of the rules and regulations. let's go down to 23. I hate it when it does that. But on 23, right here, so rules, regulations, either waived. You should never be marking this. I've actually heard of a deal where they had to waive that they waived this and then come to find out they were, they basically had special needs. They needed to do like add-ons for wheelchair accessibility and all that other stuff. And the park didn't allow it. And it's like, why didn't you, if you reviewed the rules, you would say, we don't allow these add-ons. And it was a weird 55 and over condo community. It was one of the ones that are condominiumized, and it's that. And you got, so very, very strange.
Well, also if it says in there nowhere that it's 55 or older,
Mm-hmm.
and then you come to find out it is,
Yeah.
and then if you have that waived, you couldn't use that as your.
Yeah, you can't use it for your way to get out. So you just don't want situations like that. But contingent on buyer's disapproval, so many days after receipt of park rules. I think 5 days plenty. I see some brokers put 3 days. 3 or 5, I think, is about your typical. But I think you should just watch and ask your buyer if there's any special requests they need or items they need in order to to kind of review that before they make a decision. Lease rental agreement contingency, same thing. Disapproval. This one usually might be lower in 3 days. That's about, probably, don't forget, weekends and holidays do not count. Approval of buyer contingent on mobile home parks approval with buyers. This one, you definitely want to make sure that's probably a good amount. 5 days is probably good. Or 3, either way is probably okay. But you want to make certain, got to get approval for buyer. Like I said at the beginning of class, some parks require you to apply before you write the deal, and some of them won't even let you apply to the park unless you've already got mutual acceptance. And in that case, it can be kind of a pain sometimes because all of a sudden the buyer doesn't qualify.
Another thing to ask is they don't do special assessments on these.
No.
However, they could have I had one where they were completely redoing all their water lines.
Ooh.
And so the lot rent was gonna go up pretty substantially because of that. But usually when you do a condo, you'll have there's an upcoming special assessment and this is what it's gonna be. If you don't ask that question, you won't know.
Yeah. What was I gonna say? Yeah, it states in general term V that the parking rules and regulations contingency requires seller to provide copies of the mobile home parks rules and regulations, if any, within 3 days after mutual acceptance. I know some brokers they'll upload those rules and regulations, right, PDF right in the supplements, to the listing. Probably a good idea as long as it's,
I've seen hyperlinks too.
or that. Yep. Either way is okay. Yeah, I've seen some PDFs even uploaded with hyperlinks maintained, preserved hyperlinks on the actual PDF to boom, 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 boom. Here's all of the items for the park that they can, provide in the listing details. So that's also something nice.
Sometimes when people do the resale certificate and all the HOA docs, there'll be a drop down and you can, or a Dropbox where you can click the Dropbox and it'll have all.
Oh, yeah.
Those things.
Yeah, those are great. You do have a capability in your SkySlope to actually create your own little mini link. It's a shared link to docs.
Really?
Yes, it's fantastic. You can name it whatever you want, and it's hyperlinked, and you check all the PDF items you want to be included with that. It is fantastic. It's right in your
So
SkySlope.
you could load all of your resale certificates
Yeah.
and all that stuff that's
All
so
of it.
large that you can't email it.
All of it,
Really?
hyperlinked, right
I'm
from
gonna
your
see if you
SkySlope.
do that. So when you put that all in the one, an optional, and then all of those PDFs, and then you just hyperlink that one and. Really?
Yeah, you select all of the items you want to be in the
Oh my
link.
God.
Yeah, it's amazing.
Then you don't have to do the Dropbox with the 40 different PDFs.
Right.
Wow.
It's all
I didn't know
hyperlinked.
you could do that. Huh. What is that?
See, coming to forms class pays off, people. All right, we talked about information verification, agency disclosure, pretty basic. Do not forget about the addenda line. This is their catalog. Um. It's crazy that so many brokers still just for some reason just cannot get this right. But the addenda catalog is right here. You actually do not need to make changes to this. Now, once in a while, I don't mind when you're actually fully removing something. Then I can see that be stricken and people initial that. I don't have a problem with that. But realistically, this is where you should list all of the actual addenda items that are a part of the agreement. There are a few things that should never go on the addenda line in the catalog. And first and foremost, do not write Exhibit A, legal description. You do not do that. It's still an old school thing I see a lot of brokers still do to this day. You never have to do that. It is always in there. On this one, though, you're not even going to have a legal description. Why?
It's not real estate, though, personal property.
That's right. It's personal property. It's not real property. There is no title recorded for the actual home. It is actually a certificate like in your car. You have the title to your car, right? All of us have to get when you get your tabs and you gotta sign the damn thing of what city you signed it in and all of that. It's the same thing for these homes. They're actually personal property. So there's actually no legal description. So this is the one where, definitely it doesn't state it, but on Form 21 and 28, it always states, legal is attached.
Yeah, a buddy of mine owns a number of manufactured home parks.
Does he?
And he says that a lot of times the lenders will come out and take pictures of the homes. And he said there's been a number of times where people will just grab their home and just leave without it.
Oh, yeah.
And there's a loan on it. And so then now we
Yeah.
gotta try to find out where
Where'd
where it went.
Yeah.
And those get in the middle, those you do in the middle of the night.
Oh, yeah,
Just,
I've literally heard stories of actually homes being stolen.
yeah. Yeah, because the lenders will go out and like actually take pictures, make sure that the assets are still there.
Yep. Yeah, pretty crazy stuff. All right, let's keep going. Oh, also, back to 30. Do not forget, do not ever reference a seller disclosure statement on the addenda line. This is very, very dangerous. We'd never want to sign off on a deal like that. Do not reference seller disclosure statement because by referencing the form, it may become part of the agreement. Making Form 17 part of the agreement may have several unintended consequences. Form 17 specifically states it is not a part of the agreement, and referencing the form in the agreement only confuses the issue. I still see this to today. I've seen it on a few deals. You just never, if you're the listing broker and buyer broker writes up a deal and they write Form 17 on there, you're gonna have to counter that. You can't accept a deal with that on there. Cannot. That actually could be extremely detrimental. Can you imagine the fact that if a seller made a mistake on the Form 17 and now it's actually a part of the agreement? And now that mistake actually could really cost them because the buyer could take them to court and say, look, this disclosure is part of our actual contract. It's not even about what do they, remember about the property anymore. Now they're basically certifying their disclosures. Think of it that way. You just certified every single disclosure you made. Not a good idea. Very
What are
dangerous.
your thoughts when it's not referenced on the contract, but it's all stacked in the same?
I don't mind that.
Yeah.
I don't worry about that one.
But when you accept that, what I always like to do is take the 17 out and make it its own standalone PDF.
Yes.
So that's not even like in the stack anymore.
Yeah, that's a good idea. That's how it should be done. Funny enough, when you actually send to the lender, what do you think? Should you send that whole PDF with the Form 17?
No,
No? How many of them get it though?
I don't think they need it.
sometimes send it, but what if there's like, the paragraph, this is leaking the phone.
So guess what? Just this week, got a phone call. Hey, Eric, lenders, I guess asking the underwriter wants us to do a PDF that states that, that the buyers, okay buying the home in its present condition. And they wanted to know, they had questions about the seller disclosure statement. Is that common? I'm like, well, did you send it to the lender? And they're like, yeah, it was all in it was all in the same PDF. I'm like, well, maybe in the future you might want to remove that. So the underwriter got it and they reviewed it, and there were items on page 5 that the buyer or the seller disclosed. That, yeah, some weird stuff, but
Yeah, I was
it's
trying to.
thing that it doesn't matter.
I try, like, if it's, a lot of times they'll send you an offer and it's like it's the offer, it's the Form 17, it's the
Oh.
prelim title. And it's like you have to unstack all of that stuff.
Yeah, I got a deal on one of my own deals this week or over the weekend. And the buyer broker been in the business quite a long time. I think he's at like 28 years, 29 years. He's been in longer than me. He sent me everything, all in a PDF, like literally his buyer agency agreement signed in there. His, Form 17, the preliminary title report, on and on and on. I mean, everything. All disclosure docs, his company's disclosure docs, like, we're talking like a 49-page PDF.
Yeah.
Just
And
totally
And then
unnecessary.
you gotta tear it all apart.
Right,
And that's a lot of work.
yep, it is. So please be careful of that. The one other item that shouldn't be on there also is FERPTA. FERPTA doesn't need to be, it's also a disclosure. That's why FERPTA's not in the drop-down
Yeah.
menus. They accidentally included it when Northwest MLS like put it together. The development team accidentally added it when they first updated the form. Like, I don't know, it's a few years, I don't know, about 5 years ago, 6 years ago. But anyway, like it's a disclosure. So it doesn't need to be on
One thing,
that.
I'm kind of anal with things. I like everything to match up. So if you have
In order,
in order.
I do
It
too.
should be stacked properly, and sometimes you gotta go through and change them. But it's just that if you have the financing and then you have, that's how it should. flow.
A, B, C,
it should
D, and put it in alphabetical order.
But if you get it like, if you get like, FERP is on the first
Oh.
page, and then you're like, what is this?
I literally have seen PDFs where buyer brokers have
Yeah.
mixed the pages. It's like they've mixed the whole pages. I'm like, how is the 22K above page 2
Yeah.
of the purchase and sale agreement of Form 20, of 21, and then it goes to like 35, and then like the rest of Form 21.
Stack it right.
It's like they mixed it up and then stacked it and scanned it.
Well, and then in transaction desk, you can move stuff around.
You
too,
can.
right? You just change it to 1, 2, 3, or
Yeah.
stack your stuff right.
Please do.
I don't know, I'm like kind of evil that way, but.
Oh, I am too. Signature dates. Buyer and seller should sign and date the agreement. If spouses both must sign unless the property is one spouse's sole and separate property. If there are more than 2 parties that need to sign the agreement for seller or buyer, use 22Z. That was our last forms class. How many of you guys remember that? If buyer seller is a corporation, partnership, an LLC, estate, or trust, put the entity name, the word by to indicate the person is signing as a representative of the entity, the signature of the officer, trustee, personal representative, or partner, and the individual's title. Example, ABC Corp. By Eric Scholl, its president, or XYZ LLC by Eric Scholl, its managing member, or Lee Family Trust dated June 1st, 2012 by Eric Scholl, trustee. So you really want to make certain that is how you have, people sign. You can set this up in transaction desk, in the actual person's profile for the contact. You can designate them as one of these types of things, or you can put them as other, and you can write it out that whole way. Some of them don't fit too well. If the names are too long, it might cut off. So you might need a Form 34 to put for clarification purposes. Seller is ABC Corp. By, the full long name, its president. You might have to actually do it that
Another
way.
thing to ask is, if they're a PR, make sure like if like they have the court's document that says that they are.
Yeah.
Or if they say that they're a signer for an LLC, they might ask for the articles of incorporation and title that shows that they're a member. So just make sure that they
Yeah.
actually sign off on it.
Couple months back, earlier this year, we had a deal like that where the person who was signing everything actually wasn't designated to have the authority to, they were just a member of the LLC. But it said strictly in their paperwork that the managing member of the LLC is the only person who can execute real estate contracts. It actually said it in the paperwork. Our broker didn't know, escrow caught it after they received the paperwork, so they actually had to re-sign the deal. So stuff like that, you gotta be very careful of. If it is being signed by a power of attorney, the person signing should indicate they are acting as the attorney in fact. For example, Quinn and Robin Lee by Eric M. Scholl, their attorney in fact. So you should have to, gonna have to write it out that way. If the agreement is signed by someone with the power of attorney, ask to see a copy of the power of attorney. The power of attorney has not been recorded. The closing agent will need the original to record at closing. Corporations, limited liability companies, trusts, and guardians cannot sign by a power of attorney. So be very careful with that. I mean, I had a call just last month where one of our brokers said, hey, I got a seller wants to sell their property. They're they're middle of a divorce. The wife the husband says the wife is not on the house. And that he actually has power of attorney for her. Red flags right away. Why?
Property states.
Yeah, you're in a community property state. They're married. Funny thing is, I'm like, well, obviously call your title and escrow, whole title. Guess what? Wife was on title. Do not do something like that. That doesn't even sound right. Like you're getting divorced, you've got power of attorney for them, but yet at the same time, you said they're not on the deal, but yet they are.
And then if they are going through a divorce and someone's trying to buy a property, the other spouse is gonna have to sign off.
Yeah.
Saying that this is outside of.
Outside their, yeah.
Free and, it's not community property moving forward. I have one of those too, and it's,
Sticky.
yeah.
Yeah, so just be very careful with that, you guys, if you're in those situations. All right, finally, addresses. Insert the street and apartment or unit if appropriate. City, state, fax, email is fine. MLS office number, fill in all your broker information. If you use transaction desk, it will fill in all of this information for you. And of course, you need your license number and all of that. All right, let's talk here. Obviously, do not forget number 17, buyer broker compensation. This is seller's offer, if any, right? If it's in Northwest MLS, it will auto-populate this from transaction desk. And do not forget 17B. This is how much you're getting paid. Guess what? We saw one already this month. We've already seen one blank. Had a broker like, I guess I gotta call my seller, right? I'm like, yeah, gotta tell the seller they're not asking for any compensation. And it was multiple offers too. I go, oh, maybe their buyer is paying their own buyer brokerage, compensation. Maybe they are. You don't know that. But it's up to the seller if they even want to mess with us right now. They actually went forward, and right now this is one we'll wait till the end of the month when it's supposed to close and see what happens.
Yeah.
But it's probably going to be one of those ones. Most of the time usually you guys want to get paid.
Anything for pro bono?
Yeah, do not forget that you cannot collect more in B, right? So if this was, and since we're in a classroom setting, I have to use example. So let's say there's 5 apples being offered in A and in the listing. And on your buyer brokerage services agreement, you only have 3 apples. You cannot take 5 apples. So in that case, you probably have to mark an addendum, use the 41C and give credit to the buyer for the additional apples. So if there's 2 remaining apples, marking that 41 C. And you'd be able to actually have that credit go to the buyer for the remaining apples. So just do not forget that. You can't take more. Let's say that it was the flip-flop. You're charging your buyer 5 apples, and in the listing there was only 3, but you're fine getting 3. We don't, right now, we're not really chasing those. I don't have our attorney, saying, hey, we got to get an amendment to lower it.
Which you should get on that.
You should, but it's stuff that we're not.
Yeah.
We're not chasing.
Yeah.
So it's not,
It's good
it's something that,
practice
it's a good practice too.
Yeah.
And we do have language in in office clauses that if you use the 41A to amend your buyer brokerage services agreement and you're going to reduce it, make sure you reduce it for just that one transaction. And we have a thing that states that it's being reduced for just this address, this MLS number. In the event this transaction does not move forward, it will revert back to the original agreement. So it's very nice to kind of have that language ready to go for you guys. All right, let's look at, we're doing pretty good. We got 7 minutes, not bad, not bad. Need to look at a couple of things. Title to manufactured home has not been eliminated. It can't be when it's personal property. Do not forget that. I've seen some people use the manufactured home addendum. We just did that one in forms class a few classes ago. And don't forget that in the event that your deal has the manufactured home addendum and they market that seller to eliminate title, if you're in a park, you can't. Do not accept a deal that has that. You can't. It's impossible. They can't permanently affix the property and eliminate the title like a car, to the DMV. You can't do that if it is in a leased park, leased space. You do not own that land. So be careful of that. Other thing to remember that's really and most important is the last thing we need to cover is the L&I items. So the labor and industries needs to actually, we need to talk about this one. It is right here. Why? Let's see. Eric, you want to unmute and read why? You see it? Huh? Mr. Eric, there you go.
Yeah, read why.
Yes, please.
Department of Labor and Industries Compliance Inspection. Buyers advise that manufactured homes are subject to regulation by the Washington State Department of Labor and Industries, L&I. L&I imposes special regulations on manufactured homes, including regulations pertaining to the permitting and inspections of alterations to manufactured homes. Accordingly, in addition to any inspection rights buyer may have pursuant to this agreement, including the inspection addendum, Form 35, buyer shall have 10 days to inspect the manufactured home on the property for the purposes of compliance with L&I regulations. On or before the end of the inspection period, buyer may give notice of any L&I compliance deficiencies. Upon buyer's notice, seller shall have 15 days to give notice that seller has remended the deficiencies, or this agreement shall terminate and the earnest money shall be refunded to buyer.
Okay, so we've got a boilerplate language here that the buyer has to have L&I inspections for the property. Lenders are typically going to require this. I really don't know lenders that would not. I mean, they're pretty much always going to do this because they know if they lend on this and it doesn't pass that, then they got an asset that's not very good and has issues. There is, let's see, I believe, well, let's go L&I. Nope. Let's see, labor. No. What is there in the 90s? Let me find it. The name, no. No. Here's one for the park rules, 90N. Unable to assume lease, 90D, 90O. No. No. No, 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 no. Huh? I guess they do not have, well, I am surprised they don't have that. Well, realistically, I think to best protect our buyers that you're gonna coincide the LNI inspection with your 35. So be very careful, I think, with this one. It is required, right? So you can have that. But I think that we probably have to just give it on the blank notice on the 90 form. I'll reach out to legal to verify that, but I'm pretty positive that's the only way to do it. There is no other 90 form to notice that they're gonna terminate based on that. But buyer can give the notice of any LNI compliance deficiencies. So it says right in the boilerplate language in section Y that you can do that. I did pull up on LNI's website of Washington, right? There are places to find for, is manufactured, is my home a manufactured or mobile home? So you got to find the labels. Most important thing about these labels is these are posted on the homes. A lot of times they get painted over, but they are not supposed to be removed. It does happen. You're going to have deals where that happens, but the data plate has to be, they want it on the interior of the home. A lot of times it's on the inside of a panel of a cover. Even sometimes to the cover to the hot water tank, it might be right on the inside, but you do need these. If you're listing these, you're going to want to grab that and actually, get the information included in the listing. You're going to want to have, it in there. But it states that alterations, have been approved by the LNI for compliance of the rules and regulations at the time of the approval. So they're stamped on the date and everything. So you're kind of gonna want this stuff. Where you can void these is where you end up piercing the membrane of the outer shell of the property by, drilling into it and putting in railings to steps, stairs, covers, awnings, decks, all that kind of stuff like that can actually mess that up, and you're not supposed to do it. But all the time people hire a contractor and go, yeah, I need a deck installed. I want a deck off my back. So they're like, okay, sure. And they just drill it in. Buyers have to understand that you're not supposed to be doing that. They got to be floating. There's a lot of good information on the LNI website, and it gives you a lot of different information about, what to do with these. But these are the common ones that you see. Obviously, they'd be filled in completely. They can't fill in real numbers. Otherwise, someone could try to make their own. So I think that's why they don't do that. But at least for the examples, it shows commercial coach labels. It gives all these different ones that it might have. But that is it, you guys. Any last questions to follow up? We're going to do more of a deep dive into condos, going through more of the full, that's going to take 2 sessions because it's a little more in depth. And I'm going to have Aaron actually on the Monday before the session, he's going to do about condos and how they all their kind of requirements, what they need to do. And then when we do a deep dive into forms class, it's really going to kind of bring things together. And I'll see if he can sit in on those sessions on the Wednesdays for those next classes, but those will be our next ones.
But definitely, homes in parks are completely different financing.
Okay. Definitely. All right, you guys, that is it for today. Thank you for making it, and we will see you on the next one. Take care.